Good afternoon, everyone, and thank you for attending this webinar on subcontractor bonds. As mentioned, my name is Janelle Oldacre, and I am an associate attorney with the Cummings Law Firm. The Cummings Law Firm is a full-service firm specializing in the needs of those individuals and businesses in the construction industry. So please reach out to us if you have any construction-related legal needs. So during the course of this presentation, I will provide a general overview of construction bonds and how they typically affect subcontractors. As Chelsea mentioned, if you have any questions, please feel free to shoot me an email, or you can ask at the end of the presentation. And please also note the information provided today is for informational purposes only and should not be considered legal advice. Next slide. Okay, subcontractor bonds. When working with larger general contractors or projects, a subcontractor may be required to obtain bonds. Usually, subcontractors only obtain bonds if the general contractor requires the subcontractor to do so in order to work on a project. The bond requirements are going to be located right in the subcontract agreement itself, so it is very important to review those terms and make sure you fully understand what's required. Additionally, the general contractor can provide some guidance on the logistics of actually obtaining the bond necessary. Now, general contractors often require these bonds because the owner of the property requires bonds in the prime contract, and so the obligation flows down to the lower tiers on the job. Both the owner and the general contractor impose bond requirements in an effort to transfer risk downstream to the subcontractors as much as possible. Of course, this is an unfair reality that many of our clients face. Thus, it's very important to make sure that you consider all of the risks associated with the process before signing a subcontract agreement that requires a bond. Next slide, please. So, as mentioned, risk transference is the general theme that subcontractors face when working with general contractors, especially when working with a general contractor with no prior relationship. It is, if the project is large and the subcontractor's scope of work is very broad, it is likely that the general contractor will require that the subcontractor secure a bond. This is to protect its interest as well as the interests of the owner. And we will talk a little bit about the different types of bonds in just a bit. Next slide. A general contractor may also require a letter from a surety indicating how much the subcontractor actually qualifies for before selecting a subcontractor for a particular job. As a part of the application process, a surety will request a copy of the subcontract agreement prior to issuing the bond to the subcontractor. And this is because the surety wants to make sure that the obligations aren't too burdensome, because ultimately it's a surety that's going to be on the hook if the subcontractor fails to meet its obligations. A surety will also require a personal guarantee, and that's the biggest consideration that you as a business owner has to think about before actually signing a subcontract agreement that requires a bond, because a personal guarantee could have catastrophic implications on you personally if something goes wrong with a particular project. Next slide. So if a general contractor requires a bond, it's important to secure the bond before starting work, okay? Even if the general contractor doesn't require proof of the bond before starting, chances are the general contractor will request this documentation at some point, okay? And so if you're unable to provide proof of the bond and you have already begun to furnish labor, technically you're in breach of the subcontract agreement, okay? So please don't get baited into letting this happen. You may be working with a very laid-back general contractor and think that this type of documentation is not necessarily important, but the general contractor may keep that breach in his back pocket and use that default as an excuse to terminate and replace a subcontractor if it deems it convenient at the time. So oftentimes a subcontractor will enter into a subcontract agreement without thoroughly reading all of the terms and understanding all of the obligations that it imposes. And unfortunately, failure to properly negotiate a subcontract agreement could cost the subcontractor thousands of dollars. So it's my opinion, if you're ever faced with a subcontract agreement that includes terms and conditions that you don't understand or that are new to you, I highly recommend that you have an attorney review those terms. And also remember, a contract is a two-way street, including these subcontract agreements. So don't hesitate to negotiate regarding any terms that you don't feel comfortable with or that you know from the outset is probably going to lead to some problems down the road. Next slide, please. All right. So the next, or actually the first type of bond I want to talk about are the Texas Public Work Project bonds. Okay. So now in the state of Texas, when it comes to public work projects, they are required to have a bond in place. It's very similar to the federal statute that requires a bond for federal projects. The federal statute, they call it the Miller Act, and in the state of Texas, we have a very similar statute that's designed to protect subcontractors furnishing labor and materials on publicly owned projects. Okay, although mechanics liens are the primary weapon of choice for unpaid subcontractors, unfortunately, mechanics liens are not available for these higher valued public projects in the state of Texas. Instead, subcontractors attempting to recover for non-payment on these publicly owned projects must follow the guidelines that are outlined in Chapter 2253 of the Texas Government Code. Next slide. So under Chapter 2253, the general contractor for prime contracts over $25,000 or $50,000 for municipalities, they must acquire a payment bond for the benefit of subcontractors and material suppliers that furnish labor or materials to the project. So this is good news for the subcontractor, right? This provides a more streamlined avenue to address non-payment issues. Plus, you know, there is a pot of gold, so to speak, at the end of the rainbow, instead of an insolvent GC on the verge of bankruptcy, which I've seen far too many times. The bond is issued by a surety that's agreed upon by the public entity and the general contractor, which is known as the principal. And once the surety issues the bond, it becomes obligated to pay the principal's subcontractors and material suppliers in the event the principal, also known as the GC, fails to do so. So it is a great thing to have a job on a public works project with a big bond in place. Security for you, that's what it's there for, to protect the laborers on the project. Next slide. Okay, so if the surety also fails to pay the subcontractors who have submitted a claim to the surety, those claimants or subcontractors should file a claim against the bond itself. This process is called an action on the bond, which is just a lawsuit, basically, against the surety and the GC. Thankfully, attorney's fees can be recovered for these types of suits. And needless to say, a subcontractor or a material supplier wanting to furnish labor and materials to a public project should obtain a copy of the bond prior to starting work. Okay, this will make the process of submitting a claim that much easier if the need arises. So when you're filling out, when you're signing the subcontract and exchanging these contract documents, make sure you ask for a copy of the bond. So if a general contractor fails to pay for the labor or materials furnished, and the claimant discovers that there is no bond in place, at that time, the claimant will have an opportunity to pursue the actual public entity itself directly. Now that situation is very rare, but that's another avenue to pursue payment if that situation arises. Next slide. Okay, so let's talk about perfecting a bond claim. Before a claimant can assert a valid action on a bond, it must perfect perfect its claim. Now, Chapter 2253 outlines the statutory requirements for perfecting a bond claim, which are very similar to the requirements for perfecting mechanics liens under Chapter 53 of the Texas Property Code. The notice requirements for perfecting bonds and liens are notoriously complicated. And the bulk of the fight with these types of lawsuits comes down to proper notice. If the notice was not submitted properly, the entire claim can be invalidated. Additionally, it's very important that you cooperate with the surety's investigation. After you submit a claim to the surety, they are going to send you a letter requesting a host of all types of documents that you have in your records. If you fail to provide the required documentation, your claim can be denied. So it is very important to keep good records. It makes your job much easier. It saves you money in the long run if all your documentation is in order. But once you determine that a bond claim may be necessary to secure payment, contact an attorney right away just to make sure that you follow the statutory requirements properly, and also make sure that you have all of the necessary invoices and documentations to substantiate your claim. Because once properly perfected, an action on the bond becomes a great opportunity to leverage a beneficial settlement. And again, attorney's fees can be recoverable through that process. Next slide. Okay, so now we're going to talk a little bit about payment bonds versus performance bonds. As mentioned, property owners typically require the general contractor of larger projects to obtain performance and payment bonds from a surety. Now, the difference between the two is very important. Next slide. The purpose of a performance bond is to protect the owner, okay, or the obligee, in the event that the general contractor does not perform as outlined in the prime contract. If the general contractor is unable to fulfill its contractual obligations to complete the scope of work, the owner can assert a claim against the performance bond to get the surety to fulfill the general obligations of the contractor. If the surety agrees to step in, there are a number of ways it can assist the owner in completion of the work. For example, the surety can hire a new general contractor to directly come in and complete the scope of work that was needed. Next slide. Now, payment bonds, in contrast, are for the protection of subcontractors to ensure payment for the labor and materials furnished in the event the general contractor fails to pay the laborers. Now, payment bonds are often required by property owners to protect the property from mechanics liens, which can hinder financing or the sale of the property. In order for the payment bond to stop enforcement of a mechanics lien, the payment bond must be recorded in the real property records in the county in which the property is located. Next slide. If you or your company worked as a subcontractor on a project with a payment bond in place, you should immediately, as soon as you realize that there's going to be non-payment issues, make sure that you get in place your claim. Okay, get all the documentation that you need to file a claim immediately, because as soon as that happens, you want to make sure that you submit notice timely. So a subcontractor or material supplier that's dealing with a non-paying general contractor can perfect a claim on the bond in a similar fashion to perfecting a lien claim. This requires timely serving the pre-claim notices for each month in which the labor or materials were supplied, and filing the mechanics lien timely. Okay, as you know, this process can be tricky. Even sending the notices one day late or with the wrong language can completely invalidate a claim. So be very careful when you're facing issues with perfecting either a lien or a bond claim. Next slide. Okay, so now we turn to bonds to indemnify against liens. It's very frustrating to go through the process of perfecting a lien in order to stop a pending sale so you can get paid maybe at closing, only to find that the general contractor or the owner has bonded around your lien and the property has sold in the meantime. So you've lost your leverage to get paid quickly. However, there is still legal avenue to get paid. Okay. So as we've been discussing, we know that the subcontractor's weapon of choice is a mechanics lien, because once it's perfected, the mechanics lien is a great tool to leverage successful settlement negotiations. Additionally, filing the mechanics lien is a very affordable option for smaller contractors. However, if the general contractor disputes the claim, or if the general contractor is required to do so by the prime contract, the GC may file a bond to indemnify or bond around the subcontractor's lien. This process relieves the property and the property owner of the lien claim while the dispute is being litigated. And as I mentioned before, while the bond is in place, the property can be sold, which makes negotiating much more difficult at that point. Next slide. Okay. So in order for the bond to be effective against the subcontractor's lien, the general contractor must file it in the right place. He has to file it in the county in which the property is located. Additionally, the bond must be in an amount that is double the amount of the lien. However, if the total amount of the lien is greater than $40,000, another calculation is used to determine the bond amount. So whenever a bond is filed to bond around a lien, there's also an avenue to determine whether or not the bond is effective against your lien at all. If the general contractor or the owner does not properly perfect his own bond, then it's not valid and your lien is still in place and can be used against the property owner at that time to secure payment. Next slide. Once it's established that the general contractor perfected the bond, the owner of the property and the property itself, as I mentioned, is no longer encumbered and the sale can proceed. Of course, with the lien no longer a threat, the subcontractor is in a much weaker position since the owner is no longer under pressure to simply pay the claim and charge it back to the general contractor. As mentioned, however, the subcontractor still has an avenue to get paid by the surety. The surety will be able to use all of the defenses that the general contractor would use, though. So when you file a lawsuit against the surety, be prepared for the surety and the general contractor or the owner to work together as a team against you and try to figure out any way, any method whatsoever to invalidate your claim. For instance, if the notice requirements were not met, or if the lien did not include the proper language, that's going to be an argument that the surety is going to use in order to invalidate your claim. However, if the subcontractor kept good records and properly perfected the claim, there's a good chance that the subcontractor can still obtain a favorable settlement and win at trial if necessary. And of course, all of these endeavors are going to be much more easy if you have an attorney that's kind of guiding you. Additionally, as I wrap up, I want to encourage you, our managing partner, Ms. Carolyn Crumming, she wrote a book specifically for negotiating the subcontract agreement, and there is a wonderful section in the book about subcontractor bonds, and I encourage you all to check that out. It's called Quit Getting Screwed. It's a great resource, and please, it's something you should definitely have in your library so you can reference it anytime that's needed. So at this time, I'm going to go ahead and open up the floor. If there's any questions, please go ahead and shoot them at me and we can discuss.
If anyone has any questions, feel free to send them in the chat box or unmute yourself to ask. Janelle, something that I've heard before, you mentioned the importance of keeping good records a few times during the presentation. Something that I've come across a handful of times in speaking with clients is that people are not entirely sure what aspect of good record keeping should be paramount, what is most important.
Yes, that's a great question, Chelsea. I would say the first starting point is making sure that your subcontract agreement has a detailed scope of work, okay? There should not be any kind of vagueness or ambiguity about what you are doing on a particular job. Additionally, if you submit invoices, your invoices should have a very detailed, itemized list of exactly what you're doing. Because whenever it's time to submit a claim for a bond, that is the information that the surety is going to look at. They're going to look at exactly what type of work was being done, the time frame it was being done, so they can determine if the claim is valid. And if there's any vagueness there at all, so much time can be wasted during arguing with the surety about exactly what was being done and when it was being done. That could cost the subcontractor a claim and valuable time in getting an approval from the surety. So I would say the scope of work and proper invoicing would be the best place to start when it comes to making sure your record keeping is up to par.
Awesome. And we have a question in the chat from Ashley Valdez. She wants to know if notices are required prior when claiming the bond.
Yes. Yes. So there's two different types of notice requirements. We have the public works bond notice requirements, and then we have the bonding around notice requirements. When it comes to bonding around, or the bonds to indemnify against liens, the notice requirements are practically the same as lien claims. So you have to submit those prior to actually submitting the claim. All right. And when it comes to the public work jobs, they are due 60 days prior to any kind of lawsuit on the bond. So they're a little bit different, but in either scenario, you have to send the notices in prior to actually initiating any kind of legal action.
Great. We have a couple more in the chat as well. A Walker is curious if you could explain more about perfecting. Let's see.
So I talked about that just a moment ago with the first question. When perfecting a claim against a bond to indemnify against a lien, you're going to want to follow the procedures that you would for perfecting a lien claim. And they can be a bit tricky, and it all depends on when the work or the labor was furnished for a particular project. You have to submit notices to not only the your general contractor, but also to the property owner. So pretty much everyone upstream needs to have proper notice. And I would also send it to the surety as well.
Excellent. And I've got one more over here as well. Question is, if I am building a custom home, is it a good practice to have performance and payment bonds?
Okay, so if you are the general contractor on a big custom built home and you hire a lot of subcontractors and you're unsure about their ability to perform the work and you haven't worked with them very often, I would recommend a performance bond. And if they are going to be hiring their own subcontractors for large scopes of work on the project, I would also consider requiring that they obtain a payment bond as well. So it just really depends on how big the project is and whether or not the particular subcontractor that you are considering requiring to obtain a bond, how big their scope of work is, how their experience in the field. If this is a subcontractor that you've worked with in the past and you know that they are very good at what they do and good at paying their bills, you might want to consider, not requiring a bond because it does raise the price of the home because you have to consider those that expense. But if we're talking about a newer subcontractor, with a big scope of work, I would definitely recommend that you consider requiring the bond in that case.
Awesome. All right. Does anybody have any more questions? Oh, from Theodore Jackson. I'm a painting contractor. Do you work in Illinois? Oh, I don't. Go ahead.
Well, if the question is if I'm licensed in Illinois, unfortunately, I'm not. I'm licensed in Texas and California. So unfortunately, I can't assist you with any kind of Illinois-related legal questions.
Have another question over here. What kind of % increase in cost would a bond typically cause?
That is a great question. And what I would do is I would contact a broker and ask them how much a bond would cost for a particular job, and then just make sure you're factoring in that cost when you are negotiating your contracts. And so I would have a broker, you know, I would probably talk to a broker just in general and get a range of what the bondings would look like for various projects. So I would have a list of potential numbers. So whenever I'm trying to put together my budget, that's factored in. It's kind of hard for me to kind of come up with a percentage right now. I think a broker would be a great place to start there, though.
Great. All righty. Any other questions? As a subcontractor, material supplier, do we have to wait for the other tiers, GC, and other subcontractors to take action, or can we just take action?
As soon as you realize that you have not been paid, you can take action. You can start drafting your notice letters and getting them ready to be sent out, certified mail, return receipt requested. You don't have to wait for anyone else. I would say though, make sure you review your contract, because sometimes there are clauses that are called paid when paid clauses. So you want to take a look at that. But otherwise, I feel like the sooner the better when it comes to non-payment issues, because you don't want to miss a window of time to get in your claim.
Awesome. And we have a question. Is some of this info kind of standard in the United States?
I'm sorry, what was the question again?
Theodore Jackson would like to know if some of this information is kind of standard in the United States.
Unfortunately, I can only speak as to Texas, because that's where I'm licensed, and that's my primary practice area. I don't venture out of the Texas area of law very often, but I would imagine the process is very similar across the board. But if you have a job in a different state, it's very important that you consult with a construction lawyer that is licensed in that state, so they can guide you as to any uniqueness or nuances that might be an issue in that particular state.
Excellent. Any more questions, you guys?
I'll also make sure my email is available to you guys. So if you want to shoot me an email later on, I would love to hear from you. And I really appreciate you guys sticking around and being a part of this presentation.
Absolutely. We'll have one more, and then we'll go ahead and close this out. One more question from Roselle. Can a subcontractor claim for the cost of the extension of the performance bond if the cause of the extension of time is due to the general contractor's slow productivity?
Okay, so we're talking about delay damages there. Now, when it comes to that, it's going to depend on the terms in your contract. what you can go after. Now, a lot of times these general contractors, they try to think of everything, and they want to make sure, like I said, with the risk transference, that none of it gets back on them, right? So you would have to review your contract to see if there's any kind of language that refers to delay damages on part of the subcontractor. If not, it would be difficult to try to calculate what those damages will look like. But if we can determine that they are tangible damages, there might be an avenue there. So my answer is it depends.
Alrighty, everyone. And with that, we'll go ahead and close this out. Thank you all so much for joining us. I'll send you all a follow-up email with the recording, the presentation, and Janelle's contact information if you have any further questions. Thank you all. Have a great one, guys.
Thank you.